नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Under Article 163, there are certain areas over which the governor has discretion, and these were identified in the judgment of Justice A.N. Ray in Shamsher Singh. So just to quickly run over, there were the two provisions from Article 371 where governor in his discretion can decide money, royalties and some other matters with regard to Tuensang district in Nagaland. I tried to look around to see some more background on this, but I was unable to locate something. There's just a passing reference in a couple of the books, but nothing enough. Then 6th schedule, paragraph 9 and 18. Then in Article 356, where if the governor wants to give a report to the president about breakdown of constitutional machinery, he will proceed on his own discretion without aid and advice. Then we looked at Article 239, where you are appointed as a governor of an adjoining state, and then Article 200, where a money bill you're reserving for presidential scrutiny. Again there, without aid and advice. In addition to these 5-6 points identified by Justice Ray, there are 3 points added by Justice Krishnaiyer for himself and Justice Bhagwati in the concurring judgment, which we are going to read as part and parcel of Shamsher Singh. What are these? The appointment of the Prime Minister under Article 175 and the appointment of the Chief Minister under Article 164. Under 164, the Chief Minister shall be appointed by the governor. Here again, it's a matter of discretion. It's not there in the A.N. Ray judgment. It is there in the Justice Krishnaiyer judgment. And you will appoint, keeping in mind that you will appoint a person who will carry the confidence of the House and who is most likely to win the initial vote of confidence. Second, if the ministry loses the confidence of the House but refuses to resign because both the president and the governor have sworn to uphold the constitution, they will dismiss it. And lastly, with regard to the president particularly, the Justice Krishnaiyer has given the third, where it becomes necessary to resort to an appeal to the people because the government of the day is unconstitutional, even though it has the confidence of the House. So look at the difference between the second and the third. In the second one, you've lost the confidence of the House, but you're refusing to resign. In the third one, you have the confidence of the House, yet using your majority powers, you're proceeding to do all unconstitutional things. President feels it's better to dismiss this House, dismiss the government, dissolve the House and call for fresh elections. Yet, Supreme Court cautions that this is better done if you can persuade the government to agree with it. Now, in addition to these three, remember what Justice Krishnaiyer said, without being dogmatic or exhaustive. And today I'm going to do the last of the 3 cases that I'm doing for President and Governor. And this is yet another case in our case material, Madhya Pradesh Special Police Establishment versus State of Madhya Pradesh. And this is opening up another 3 areas where the governor has discretion. So remember, our final listing where governor's discretion requires us to look at this judgment also. Now, the facts of this case are interesting. One of the ministers was charged with a wrongdoing. Okay? And cases were filed that he used his ministerial authority to benefit somebody, etc. And there was permission sought for prosecution of a minister. Please remember, because you have studied IPC last year, the chief minister and ministers are all public servants. And if you want to prosecute a public servant under section 197 of the CRPC, you need to take the prior approval of the government. So prior approval had been sought to prosecute the minister for his basically corrupt acts. The chief minister and cabinet sat together and they felt that no prima facie case was made out and therefore they refused to give permission. Now, this is pure, the right to give permission for prosecution is clearly an executive act. It's not a legislative act, it's not a judicial act, it's an executive act. They refused to give permission to prosecute this minister. And therefore, this case has been filed and it's reached the Supreme Court. Okay, that's the background of this case. Now, before this case, in the 1970s, there was a similar case involving a chief minister. And I want to do the R.S. Nayak versus Antule together with this particular case, Madhya Pradesh Special Police Establishment, to find out an answer about whether there is a difference in the position in the cabinet between chief minister and the minister. That's a side thing that I want to find out. In the 1970s, Mr. A.R. Antule was a chief minister of Maharashtra. And he had floated something known as Indira Gandhi Priyadarshini Pratishthan. Okay, some name like that. This was a trust. And what he did was, he arm twisted or he got various sugarcane cooperatives, sugar mills, other industries in Maharashtra to give money to this Indira Priyadarshini. In the name of the chief prime minister, Indira Gandhi set it up. He twisted various people's arms in order for money allegedly to put into this trust. And it was alleged that all this pressure and coercion that he brought to bear were corrupt practices, and they wanted to prosecute him under Prevention of Corruption Act. Now, A.R. Antule, who was it who wanted to proceed against him? Another politician called R.S. Nayak. And between Mr. R.S. Nayak and Mr. A.R. Antule, there have been no less than 4 times that the matter has come before the Supreme Court. So, A.R. Antule versus R.S. Nayak, number 1. R.S. Nayak versus A.R. Antule, number 1. R.S. Nayak versus A.R. Antule, number 2. And this has in fact become a very celebrated case for understanding what the power of the Supreme Court is under Article 136 of the Constitution. Maybe when I come to judiciary, I will do it a little more, give you further facts of the case because it's extremely interesting. For the first time, you find that the Supreme Court under Article 136 set aside its own judgment in a 5-judge bench case saying that it was improperly decided. So it's a very unusual case in very many ways. Now, when prosecution permission had been sought to prosecute Mr. A.R. Antule as chief minister, the Supreme Court had said that because there was a prima facie case, permission can be given by the governor, even though the cabinet had said that there is no case made out against the chief minister at all. And in that case, the Supreme Court had held that the governor is within his rights, in his discretion, to grant permission to prosecute Mr. A.R. Antule, even though he was chief minister. Now, this was the precedent on the basis of which this matter came before the Supreme Court. And the Advocate General of Madhya Pradesh argued that R.S. Nayak versus A.R. Antule was a precedent only to permit governor to exercise his discretion if a prima facie case were to be made out against the corruption of the chief minister, because the chief minister presides over the cabinet and therefore it is likely that he may not give permission to prosecute himself. In these extraordinary circumstances, there is a case made out for the governor to exercise his own discretion contrary to the aid and advice and proceed to give permission under Section 197 CRPC. And the argument of the Advocate General of Madhya Pradesh before the Supreme Court was, when permission is sought to prosecute a mere minister, the minister does not preside over the Council of Ministers. It is the Chief Minister who's presiding. Chief Minister and his cabinet have taken a view that there is no prima facie case of corruption against this minister. Therefore, when they have said no permission should be granted, this is distinguishable from the case of A.R. Antule. Now, this is a technique which I'm sure you have, as students of law, come across, but I just want us to spend a little time. If as a lawyer you find an inconvenient precedent, in this case, Chief Minister, alleged corruption, governor not bound by aid and advice. That's the ratio on that point in R.S. Naik versus A.R. Antule. You will, if you don't want it to apply, you will distinguish. And how do you distinguish? On facts. Always on facts. Always on facts will you distinguish. And that's really what the Advocate General sought to do. That in the case here, it was a minister's corruption which was discussed in the entire cabinet. This is a high body, and once a higher official such as the chief minister has applied his mind and come to the conclusion there is a no prima facie case, since there is no self-interest involved and it is only a fellow minister, the chief minister's aid and advice should be taken as final and there cannot be any discretion. At this particular point, on the court says that even though in the Council of Ministers, the Chief Minister and the Minister are at par, they are at the same level. Number two, is there a question of bias? Okay, now this is a principle of administrative law that you will study in the 4th semester, but let me just, when they allowed, I'll tell you finally the decision of the Supreme Court. They said the governor has examined the papers and he is finding out prima facie a corruption case against the minister. So he has proceeded to give permission under 197 CRPC, prima facie case made out. But Chief Minister and Cabinet said no prima facie case made out. Is there a question, are we rejecting the Cabinet decision because of bias? Or are we rejecting it on other grounds? And this is actually, though it may appear to you a minor point, it's actually a very important point. The reason for rejection of the Cabinet decision is it because we believe one of them was charged with corruption. Any decision taken by the Cabinet is tainted or is stained by bias. Is that the reason why Supreme Court has rejected it, or is it some other ground? And you will find several paragraphs in this judgment deal with the question of bias. And when I don't want to teach this topic of bias because you're going to study it, but there is, something that we call as apparent bias or the real likelihood of bias. And there's a subtle difference between the two. In the real likelihood of bias, you're not really asking, was there bias or not? But you're merely saying, is there a likelihood of bias? For example, if you are related to one of the parties in front of you, you may be a Satyavan judge who is never going to be swayed. You may be like those Panch Parmeshwars in the Premchand novel, never going to get swayed. But there is a perception in the mind of the public that there is an apparent bias. It appears to be. Because justice should not only be done, it should be seen to be done. Okay? So, correct way is to recuse yourself from such a case. The real likelihood of bias is that there is actually a strong connection and there's all likelihood that you may be biased. So there's apparent bias, there's real likelihood of bias, and both of these are grounds to set aside a decision because there is bias in it. Now, interestingly, what the Supreme Court says is that we are not accepting the decision of the Cabinet that permission to prosecute should not be given, not on the grounds of bias, but because they examined the case file and they came to a decision that there is no prima facie case made out against this tainted minister. Governor has studied the same file, same material, and the governor has come to the conclusion that there is, at the first flush, a prima facie case made out against the minister. Therefore, not on the grounds of bias, but because the initial judgment by the cabinet or the council of ministers appears to be irrational, because the papers are revealing that there could be a prima facie case. So a decision not to give permission appears irrational. And they explain why they are not willing to say bias, but they're using the word irrational. Bias means that you have a tendency to be prejudiced for or against a party. Irrational means that no reasonable person would have come to such a conclusion. Both may result in saying, no, this is wrong, but the basis of it is wrong. Now, why did they not choose bias? Now, if you read this judgment carefully, it appears to me that because the chief minister and ministers who sit in the council of ministers or cabinet meeting to take a decision whether to give prior permission for prosecution or not is such a high constitutional body that the Supreme Court does not want to presume that this high constitutional body, which is a council of ministers, is possible for it to have a bias at all. So because it's a constitutional body, they have very cautiously presumed, it's a presumption, as you know under Evidence Act, rebuttable, but there is a presumption that the decision of the Council of Ministers is irrational but not biased, because they don't want in the public eye or through their own judgment any aspersion cast on a high constitutional body such as the Council of Ministers. And this is something that you will find across judgments in different branches of law. There is a presumption that when a discretion is given to a high constitutional office, the presumption is that the exercise of that discretion was done fairly and correctly. It is very, very difficult to allege and then to prove what we call malafide in a high constitutional body. In fact, it's virtually impossible to establish malafide. And if a charge of malafide is done, and you will know it when you begin to practice, you will require a personal sworn affidavit from the president himself. So these are the peculiar rules of writ jurisdiction. Though the case will be against the government of the state, the moment you say that there is a malafide against a person, usually because of a very important case in Nandini Satpathy, sort of change the rules of practice, you need a personal sworn affidavit from the person against whom a charge of malafide has been. So even if you're a litigant and you want to make these statements, a lawyer usually will try to persuade you not to make allegations of malafide because it may result in greater problems for you as a litigator. So the court says, in this case, because the governor came to the conclusion that there was a prima facie case that the minister may have been corrupt, that prosecution is the necessary way. This is the rational way. So what do we have here? We have two additional grounds for governor to exercise his discretion. So I think there were 5 or 6 and then 3 more by Justice Krishna here. I don't exactly remember the number. We were already at 7 or 8. We added one, R.S. Naik versus A.R. Antule, when an allegation is made against the chief minister in a prevention of corruption case, then the governor can independently study the file, and if he comes to a conclusion that there is a prima facie corruption case, he can give prior permission to prosecute under 197 CRPC. And the Madhya Pradesh Special Police Establishment adds the second, which is even if the cabinet believes otherwise, if the governor comes to the conclusion that there is prima facie case, against that aid and advice and on his own discretion, he can go. And yet another exception that we are carving out under Article 164. The The last one is what we call statutory functions of, and there's reference to the statutory functions of the president or governor. What do I mean by the statutory functions of the president as opposed to the constitutional functions? The constitutional functions of the president are those laid down in the Constitution: pardoning power, right to enter treaties, commander-in-chief of the armed forces, all the executive powers of the union, then certain presidential powers that he has to confer Article 258, which now is also treated as part of the executive powers of the union because Jayantilal Amritlal Shodhan is now overruled by the Shamsher Singh case, etc., etc. Proclamation of emergency. There's so many. But what is a statutory function? I think the best example for us is the Delhi University Act. Delhi University is a pre-constitutional act of the Central Legislative Assembly, 1922. This is 2020, so another 2 years we will be 100 years old, and I hope we're all around to enjoy and celebrate this. It's a grand old university. I'm very fond of it. I studied in it, I have taught in it, and it's a real privilege to teach here and to teach all of you. Now, our visitor is the President of India. He's the visitor. And since he is the visitor, he has functions cast upon him by statute. Now he's cast upon him by statute. So what are those powers of a visitor? Visitor can order a visitorial inquiry against a vice chancellor. It's very few universities that have a provision of visitor. Very few. For example, in all other cases, it's usually the chancellor. In all state universities, most of them, it's the chancellor. But some of our central universities have a visitor. Now, this duty of a visitor, the visitor also appoints the vice chancellor. So our vice chancellor, Professor Yogesh Tyagi, was shortlisted by a selection committee and he was appointed by the visitor. Visitor can do, as I mentioned, an inquiry. Visitor can also, if for any reason there is a dispute between the academic council and the executive council, if there is a dispute between the university court and the executive council, some of these very extraordinary things that have never happened actually, but the possibility exists, the visitor will then step in. Now, this duty of the President of India, who is the visitor, is what I'm calling as a statutory duty. In statutory duties, the President exercises his own discretion. He operates on his own satisfaction, and he is not guided by the aid and advice of the cabinet. And so when you look at Madhya Pradesh case, you will see the third additional ground for discretion that has been added by the Madhya Pradesh Police Special Establishment case. And they take the example not of Delhi University. I took that because I thought that's an easier example for us to understand. They've taken the Vaishno Devi, important Vaishno Devi judgment of 1997, I think, Purinath. Vaishno Devi, under Article 25, we have the power to take over the management. We, meaning the government, can take over the management of the temple because there's a constitutional power conferred on them, which is exercised through the different states have different acts. And using such a legislation, the Vaishno Devi temple, which was earlier sort of run by a small set of families there, was taken over by the J&K administration. And in exercising those powers, the governor had to act. Okay. Sorry, my spelling is wrong. Yeah, governor had to act. Now, those powers which are conferred on the governor by the Jammu and Kashmir taking over Vaishno Devi Act are statutory powers. And in these cases, there is no need to be aided by the aid and advice of the government. So, this is another point that is added in the Madhya Pradesh case. So have certain areas where, so let's take the governor for the start, governor of a state. It has all those constitutional provisions which we examined yesterday, 371, 356, 200, 239, 6th schedule, article 164, where you are exercising discretion. Disqualification also is another one for President, 103, and the equivalent one there. I can't remember the number. Then you have the additional 3 cases that were added again in the Shamsher Singh but by Justice Krishnayya's judgment. That paragraph, by the way, is reproduced in the case material in the Madhya Pradesh Special Police Establishment case. So that, remember that paragraph 154? It's reproduced here. You can read it. Then we have 3 additional grounds that are noticed by the Supreme Court in Madhya Pradesh Special Police Establishment dealing with governor. Chief Minister, allegation of corruption, no aid and advice, independent discretion. Alleged corruption charge against a minister, prima facie, if the governor feels he acts on his discretion. And lastly, statutory powers which are outside the scope of the constitutional limitation of Article 163. When it comes to president, it appears has those 3 discretions which have been pointed out by Justice Krishnayya, but this is not a full and final case because he himself says without being exhaustive. So what is the area of discretion when it comes to the president? Is determined by constitutional convention, appointment of a prime minister, dismissal of a prime minister who's lost the confidence of the House yet refuses to resign, or where the prime minister has the confidence of the House merely because he has full majority, yet is proceeding to do unconstitutional things and it requires a fresh mandate once again. This is, of course, the trickiest because you would really have to go against the principle of parliamentary democracy, and you would have to then say that supremacy of constitution is even more important than parliamentary democracy. Luckily, it's never happened until now, but the possibility exists. And therefore, when you study it, put it down, how many you get, and remember that nothing is ever closed. Maybe you're going to be the lawyer or the judge that's going to determine a new place of discretion when you are either an advocate or a judge. Okay, so I think that's pretty clear. Now I want to come on to union territories. Okay, so when you study this, remember that you make a list for the president, you make a list for the governor, and now I come on to union territories. And I'm going to be looking at Article 239 and 239AA.
नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।